Good afternoon, everybody, and welcome to today's webinar, Countering Witness Intimidation and Forfeiture by Wrongdoing. Today's program is presented by Equitas. My name is Mary McLeod, and I'm an Associate Attorney Advisor at Equitas, and I will be moderating today's webinar. Before this webinar, you should have received a link to a pre and a post test. Please use the same anonymous unique identifier you chose when taking the pre-test when completing the post test. If you have a question during the presentation, please enter it in the chat box or feel free to speak up. You're also welcome to contact us directly at any time following today's presentation, and we will send you our contact information during the follow-up. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, human trafficking cases, by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As a national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website at equitasresource.org. You can also follow us on Twitter, Facebook, Instagram, and LinkedIn. The link to each is available on our website. Today's webinar is supported by the U.S. Department of Justice Bureau of Justice Assistance. The information presented in this webinar does not necessarily reflect the views of the BJA. Presenting our webinar today is Equitas attorney John Kurland. Before joining Equitas, John Kurland worked for 16 years as a prosecutor in the District Attorney's Office in Berks County, Pennsylvania, serving as Chief Deputy District Attorney, Chief of Trials, and Assistant District Attorney. Throughout his career, John has successfully prosecuted a variety of offenses, including domestic violence homicides, campus sexual assaults, cold case sexual assaults, intimate partner violence, stalking, child pornography and exploitation, child abuse and molestation, and human trafficking. I will now turn it over to John.
Mary, thank you so much. And Tara and the rest of the St. Paul office, I want to thank you for letting us participate and help facilitate this part 2 of this 4-part webinar series. It's part of the IPS Innovative Prosecution Solutions Project. For folks that are rejoining us after part 1, which, if I recall correctly, was the week before last, welcome back. It's good to virtually see you again. For those who haven't joined us previously or catched the recorded version of part 1, bringing the victim's voice in, it's so good to have you. So this is part 2 of 4. The week after next, or I know the week of September 29th, I'm not sure if that's quite the week after next. We're going to be talking about admissibility of digital evidence, but today what we're going to be talking about is forfeiture by wrongdoing. And of course, in talking about forfeiture by wrongdoing, what it is, and really strategies to set up a foundation for its admissibility and litigating it, we really have to talk a little bit about witness intimidation and how that it takes place in domestic violence and intimate partner violence cases, because that really is what provides the context for any sort of discussion or conversation on forfeiture by wrongdoing. So what our goal is to spend about 20-25 minutes talking about some witness intimidation, witness tampering dynamics that are part of domestic violence cases, and I think will probably be familiar for most folks here, and then dive a little bit deeper into forfeiture by wrongdoing. For folks who already attended part 1, my hope is we're still going to have some interactive portions of this presentation. We might not have quite as much opportunity as we did last session. That's not just because we're on 60 minutes rather than 90 minutes, but just sort of the design of this content. So with that said, let's get into the specifics about what our objectives are for this presentation today. So again, sort of setting the table and beginning a conversation around witness intimidation and witness tampering in domestic violence cases. We do want to talk about ways we can be proactive and talk about ways we can reduce opportunities for intimidation. And part of that strategy is then going to sort of tangent into educating and how to educate victims about intimidation And our responsibility as prosecutors, as law enforcement, as advocates, as really any member of a multidisciplinary or community response to do that. However, intimidation in any sort of case where there's a pre-existing relationship between an offender and a victim, let alone one where there's an intimate relationship between the victim and offender, intimidation to some degree is going to be inevitable and should be anticipated. So taking into account and anticipating that intimidation is going to be occurring in these cases, we want to talk about how we can use that intimidation to help convict the abuser, hold them accountable, regardless of whether our victim is going to be testifying or able to participate in a prosecution. One of the primary vehicles or ways we're going to be talking about how to use intimidation to help convict the abuser is how to litigate motions and present evidence under the doctrine of forfeiture by wrongdoing and what that means. So just to sort of give me a flavor here, I know we've got an attendance, my attendance counter says 14 people. I know 2 of those people are Mary and myself, so I guess of the remaining 12, if folks could just sort of sound off in the chat window, how many people have utilized forfeiture by wrongdoing in your cases, had it litigated it yourself if you're a prosecutor, or seen a prosecutor litigate it in a case you're involved with if you're law enforcement or an advocate? If folks could just let us know in the chat window, and just want to sort of get a census or a vibe for how many people might have used it or had to have experience with it. Linnell says I have approximately 5 or 6 times. I might draw on Linnell as being our resident expert then too. So, and this wasn't just a ruse to get people to volunteer for participating. I actually was legitimately curious. Okay. I've used forfeiture by wrongdoing after litigating and winning the ability to use the evidence. Defendant then pled guilty. Okay. Drafted the motion memo several times, but only litigated it twice. And that's from the boss, from Tara. Okay. Well, I don't want to spend too much time, but if folks want to add in as we continue our conversation about witness intimidation, I do know for any silences or lulls we get there, I now have 3 people I know to sort of call on to sound off and use a sounding board for things. So thanks. So here's the first question. Actually, I'm going to exclude Linnell, Maggie, and Tara from this question, but it is an initial sort of way to frame it or set the table here. With witness intimidation, witness tampering, however we want to define it or what sort of label we want to use, what do you think of when you think of witness intimidation? And if you can participate, you can either take yourself off mute and join in by audio or join in by chat window. Just if you could contribute your ideas of what intimidation looks like and it can be a spectrum of sort of examples of intimidation or tampering you've seen in domestic violence cases. Well, now I am, just to sort of get rid of the silence. I think I am going to sort of ask Linnell, who's oh, here we are. Have some input in the chat window, calling the victim from jail, telling them to recant. So that's sort of the vivid or more explicit intimidation. Shutting off the cell phone of the victim or not paying bills. Allison contributed that. And that's, these are good examples. And I thank you, because they sort of, what I like about these examples is they sort of illustrate the poles on the spectrum of witness intimidation or tampering. On the one hand, you have something really explicit and that I think anyone maybe stereotypically would picture as intimidation. The cell phone or the paying off the bills, that is intimidation. It's going to cause victims not to participate. Conceptually, it might be harder to get people to understand how that is intimidation, and that doesn't always fit into our conception. Evicting the victim out of a shared apartment, threatening violence. So there's a lot of experiences I hear being shared here that recognize the range of what intimidation is. And that's usually, I think, one of the biggest sort of hurdles with domestic violence in criminal cases generally is the preconception that when we're dealing with witness intimidation, the preconception of it is almost like in the Godfather movie where the witness, the Hollywood producer, director, I forget which, wakes up with the severed horse's head in the bed to not testify against the family, against the Senate committee or congressional committee. That's usually the preconception of what intimidation is. And things like that, or that sort of explicit threats of violence and force, that is intimidation, but that doesn't capture the range of intimidation or behavior that can be designed to get people or just wear people down from wanting to participate in the system. And one of the factors that leads to so much attrition. So one of the resources, and there's a link to it on our website, we talk about, and throughout this presentation, we're going to be talking about witness intimidation in really the broadest sense. And that's anything done with the intention or purpose of altering or preventing a witness's testimony or report to law enforcement or retaliate against a witness for such testimony or report. So really, when we're talking about witness intimidation, the sort of definitional reference I want to offer folks is that of a wide spectrum, either really explicit violence or something more subtle, and things that people might not stereotypically conceive of as witness intimidation or tampering or comes to their head. And of course, what studies show is that these are really especially prevalent in domestic violence cases, which makes sense when you think about it, because one of the things you need for witness intimidation and witness tampering is offenders who know their victims, who have access to victims. And intimate partner violence cases and domestic violence cases, there's not a lot of cases on the radar that are going to have this much overlap of between the offender's life and the victim's life, and more opportunities for access by the offender to the victim to exert either subtle or not so subtle modes of witness intimidation. And that's what our studies show and what are referenced here. So the other point we want to talk about and recognize as well is just because we don't see it in our cases, in our domestic violence cases, is we shouldn't assume that it didn't happen. What we want to sort of approach conceptually is just like maybe in sexual violence cases, we want to be approaching with the mindset that there's a strong potentiality for the offenders in those types of cases to be serial offenders. We want to recognize that in domestic violence cases, that witness intimidation and witness tampering, it's the norm. It's not going to be the exception. And usually the only kind of intimidation we do capture, especially if we don't have very active efforts to educate our victims or to prevent witness intimidation, the only kind of intimidation that we're going to capture is the unsuccessful intimidation. But for those cases where we're dealing with attrition, and attrition that can take the shape of a victim just being adversarial with us, not cooperating, participating in a proceeding, recanting, minimizing the harm caused, or just the victim that drops off the radar, who's not returning calls or we can't find before, the likely reasoning or account for that is this witness intimidation that we failed to identify, that in this one case that we didn't succeed in preventing, that we didn't exceed in turning against the offender. So again, attrition and victim drop-off, it's a common reality in domestic violence, intimate partner violence cases. And the reason for that is because of the prevalence of witness intimidation. And usually the efforts of witness intimidation, it's going to be overlapping with the same sort of dynamics that are going to affect domestic violence, intimate partner violence cases generally. Those sort of methods and modalities of power and control. Now, again, because we want to get into a lot of the substance of forfeiture by wrongdoing, I'm not going to spend as much time talking about witness intimidation, but it does pay, and it's important to have some sort of cognition of what witness intimidation is. And I think a good way to sort of understand the range of witness intimidation that can happen in domestic violence cases is the power and control wheel. The same thing we're using to understand domestic violence cases in a manner that's more holistic and deeper than just that initial police response for a 911 call, but we try to understand the cycle of domestic violence. And of course, witness intimidation takes shape in this same sort of way. and things that are recognized in the contributions people have made to the conversation already, and things that I didn't reference: threats of deportation, withholding immigration papers, leveraging children. All these things that the victim holds dear, that the victim loves, that the victim cares about, can be leveraged against them by offenders to impact a victim's ability to participate in an investigation or a prosecution in the form of testimony or otherwise. And what's helpful with the power and control wheel is that when we're trying to think of intimidation or identify intimidation, sometimes it can be helpful to sort of reference this power and control. This in the same way in our domestic violence cases, when we're using the power and control wheel to maybe identify the motive or the intention or the motivation of our offender, it can also be helpful and to maybe identify some of the methods of witness intimidation as well. Which is going to be helpful because a lot of forfeiture by wrongdoing, when our witness can't participate through the offender's wrongdoing, we're going to want to be able to identify that wrongdoing. And of course, a lot of the tactics in intimate partner or domestic violence cases, because this cycle of power and control is built on almost a process of grooming, an evolved sort of status that grows over a cycle. A lot of the tactics in intimate partner violence cases, it's going to be subtle to that relationship between the offender and the victim, and things that our victim recognizes that may not be explicit to folks looking at this relationship from the outside, but may be implicit to our victims, such as a lot of nonverbal cues that the victim recognizes means that a physical assault or harassment is going to come, or that they're going to be abused, or things that the victim has recognized through the cycle of the relationship that cue the victim as to when danger is going to occur, and cue the victim into taking actions to prepare for it or make some effort to minimize it. And that has to be recognized as well. And certainly we can see this in court sometimes. An offender facially might present themselves as not being really intimidating at all, but to the victim, it's intimidating just because maybe the look the offender is giving them sitting over the defendant's table is the same look the offender has given the victim hundreds, if not thousands of times before physical violence ensued. I'm glad someone mentioned jail calls when we were talking about what intimidation can look like, because of course, a lot of intimidation, and this is what can be difficult for a lot of people not familiar with domestic violence cases, is going to involve emotional appeals designed to get the victim not to participate in a prosecution, such as a promise it's not going to happen again, that they're sorry, but not using threats, but more subtle forms of manipulation and methods to control the victim. A lot of this is going to be evident in jail calls, and you're going to be able to hear these jail calls, especially right before proceedings are coming up in the case, whether it's initial court hearings, evidentiary proceedings, or bail or bond hearings. There's a good sort of study about this from the study referenced here from 2011, but talks about after listening to 3 hours of jail calls, each for 17 men in custody on domestic violence charges, the researchers observed that the more common sort of control or intimidation or tampering technique is going to be emotional appeals. We want to be able to recognize that. And the reason why this discussion or conversation is going to be important by forfeiture by wrongdoing is because when our victims are not available to court, we have to make arguments about how the defendant's wrongdoing caused this victim to be unavailable. And being able to identify these different methods of wrongdoing or methods of conduct perpetrated by offenders to make the victim unavailable is going to help us meet our argument to make this intimidation hurt against the offender and allow us to bring in a victim statement. So we already talked about when intimidation occurs, of course, that it's going to be a lot epitomized around power and control dynamics. And really, it escalates the closer we get to trial. Now, how do we counter witness intimidation? Well, the one we're primarily here to talk about is using intimidation evidence effectively, especially through methods like forfeiture by wrongdoing. But that's not the only strategy we want to talk about for countering witness intimidation, because we, of course, want to touch on a little bit about charging intimidation crimes, not just considering them the cost of a case. We want to talk about methods about working with victims to preserve evidence of intimidation and not putting that burden on victims without any sort of outreach or introduction by us. Ideally, we also want to reduce opportunities for intimidation. So hopefully we don't have as much attrition to begin with. And maybe all this discussion about forfeiture by wrongdoing won't be necessary, or will be not as necessary, because more victims will be able to participate because we can minimize or reduce the impact. So educating victims about witness intimidation, what we've discussed so far is really, I think, intuitive to a lot of people who've worked in the field a long time, is that intimidation can take a lot of shapes and a lot of forms, either something explicit or something more subtle, like emotional appeals and things of that nature, or using children, or what at a facial or surface level appears like an ancillary type proceeding, such as custody or deportation or immigration proceedings. But victims don't know this. Victims don't come in with the same sort of context we have. A lot of folks in the public at large, where our victims come from, might only be sort of conceptually thinking of intimidation, not as that emotional appeal, not as what to them might come across as a heartfelt apology, but they might only conceptualize witness intimidation as that example from a Godfather movie or a mafia movie. But it's going to be our role, both as law enforcement, as prosecutors and advocates, and across the multidisciplinary framework, to be educating victims about what intimidation can look like, and talk to victims about what they can do if they are being intimidated. A lot of times how offenders are going to be sort of operating through this cycle of methods of power and control is victims might not even realize or be able to identify when intimidation is being executed. And we can help talk to victims about the really serious nature of any kind of intimidation and educate them about things that they should save, and talk about ways they should save it. Oh, I would ask you, though, if you have your mic on, if you could mute yourself, unless you're participating. Just, we don't want to hear any of the important conversations you might have going on outside. Of course, what we need to remember, though, and this can be a big tragedy, is a lot of times, sometimes systems just leave it to victims to leave it with they have the burden of investigating intimidation and bringing it to us, rather than understanding that victims is really reporting intimidation. It's really just the first step. We have to also realize too that a lot of times victims are going to be the own best planners of their safety plan. They're going to understand what's going to put them more at risk or less at risk. A victim might be getting intimidating or harassing phone calls from the offender. Victim might also realize, like, oh, gee, if they take away the offender's phone call, it's not like the offender's going to give up. They'll just find some way to harass me or contact that I can't control or that I don't know about. So we want to be recognizing that the victim is going to be taking into their own safety into account too, in ways that might not be as convenient for our expectations, but that we need to adapt and adjust to. So with witness intimidation, it's not something an add-on. It's something we want to talk about with them during every conversation. We want to proactively bring up, hey, talk to me. Has the defendant's family or friends, have they talked to you about the case at all? Has the offender reached out to you? And rather than just even asking about the case, make it even broader. Have they reached out to you at all? Have they talked about childcare? Have they talked about financial matters? Bring up with victims about any sort of contact they've had with the offender's network in their day-to-day life. Talk to the victim about what intimidation can look like, that it can be a lot of sort of emotional appeals of apologies and promises that this wouldn't happen again, and talk to them about ways to preserve evidence when it happens. Whether it's a journal, whether it's taking screenshots of things on the phone, if it's on text, whether it's saving voicemails, what have you. In reporting and being able to respond to witness intimidation, we want to make it an easy flow. We don't want the victim to have to call 911 and be oriented to a whole new law enforcement personnel or person every time some sort of contact happens. We want to be able to identify a person they can contact, the victim can contact readily and quickly when intimidation is occurring, who'll be familiar with the context of the case or what's occurring in these types of cases. And we want to have services in place that the victim can utilize so that there is no final safety plan, but so that safety planning can be adjusted and adapted. Any kind of contact by the offender is something that should alert us and that we never want to minimize or just take for granted. So one sample or tool I would offer you is something prepared by the Denver City Attorney's Office. This is a prosecution and code enforcement. I think they're a misdemeanor prosecutor's office as well. And we can get you a hard copy of this, but this is an example that we offer, something that they give to victims just about witness intimidation and about what happens. And no matter what he says, abuse is not your fault. You cannot drop the charges. The city of Denver, what happens is the defendant's fault. It's not your fault. Talking about what can happen while the case is pending, attempts to rewrite history, minimizing what happened, excuses for what happened. Oop, I went too fast, sorry, because we couldn't fit it all on one page. Talking about blaming the victim for the arrest, attempting to make the victim feel guilty, trying to talk the victim out of appearing for court, or even the old sort of traditional stereotypical intimidation, such as explicit threats and things like that. The other thing they do too is when they talk about potential range of penalties too for the cases, you can't see it. This case results from a city charge. The maximum penalty for a city charge is up to 1 year in jail. And that's important too, because one of the reasons the offenders may try to manipulate or guilt the victims is talk about like, this is essentially going to end everything too. And just having that. And I think how it's utilized in the Denver City Prosecutor's Office, this isn't the sort of paperwork that's just given to the victim, but folks actually sit down with the victim and discuss it with the victim. And it's used as a tool. And then it's not just this is given to the victim and forgotten about, but it's also hopefully followed up with proactive questioning and inquiring about any sort of contact about the case they've had at subsequent opportunities. So if this is something that you want to adapt to your current resources or be interested in, please let us know. We'll get you a copy, either a PDF or even at a minimum, the copy of these slides. So in terms of, and I don't want to dwell too long on this because I want to get to forfeiture by wrongdoing, but we also want to talk about limiting opportunities as well as educating victims, limiting opportunities for witness intimidation. And this is, again, where a lot of sort of multidisciplinary collaboration is going to be critical. The sort of things where intimidation can occur going to court, waiting in court, recognizing that, of course, it's not just we give a subpoena to the victim and it's their obligation to get here, but engaging with allied partners to work on transportation, finding people that can accompany the victim to court, finding places where the victim can wait outside of the presence of the defendant or even the defendant's network. Hopefully helping the victim if there's childcare issues, trying to assist with that. So God forbid a victim doesn't have to rely on the defendant's family for childcare as they go to court. We also want our court personnel, either the judge's staff or bailiff or deputies or folks responsible in the courtroom, to recognize overt and subtle witness intimidation and what that can look like too. I've talked about this, having formal and informal witness rooms. In one ways with COVID and in a lot of jurisdictions, this might even be easier to prepare for this sort of separation because with social distancing, hopefully we don't have witnesses all gathered or hovered in one place, and courts are more patient as we bring in witnesses one at a time. Talk to victims about safety planning throughout the case too, which includes, it's not our job or it's not necessarily a victim's obligation to abandon or get rid of all social media, but we should have conversations with victims about the risks of social media, including talking about the case and how that can impact the victim and their involvement with the case. Most of all too, we want to appreciate that sometimes victims aren't going to be vocal about discussing their safety concerns, sometimes because they can't articulate, sometimes because they're embarrassed by it. So we really want to give an opportunity to listen to victims about how they would feel safer, and just ask, tell us what are your fears about safety? Can you talk to us about that? And we can work on ways that maybe we can figure out solutions for. Because again, sometimes a victim's going to manage their own safety by having what they perceive as managed contact with the offender, so that they have a known rather than an unknown. We also want to be charging intimidation crimes and proactively investigating witness intimidation, so that when this victim gives us a report, we're not just filing it away as another piece of paper in our file or another note in our file or another email, but we're recognizing it as a potential for an independent crime. Part of this in domestic violence cases means in our investigation strategies, recognizing that when the case starts, we assume there's going to be subsequent crimes of intimidation perpetrated and committed by the offender. Like the initial charging of domestic violence or assault is usually just the beginning of the case, because at some point there's going to be subsequent intimidation. And the open question is whether we as a system are going to be able to capture enough evidence of that to properly and appropriately charge about that. One of the ways we can prepare for intimidation is, especially with victims who've been in the system before, is ask them about prior incidents of domestic violence and what happened to those cases, what happened during those cases, or for cases oftentimes it didn't fully mature or have a disposition, talk to the victims about why, what happened. And of course, that's common to any kind of modern domestic violence practice, the labor intensive, but often so rewarding habit of monitoring jail calls and visits is where we're going to be finding evidence of our intimidation, and especially for forfeiture by wrongdoing. So we talked about reviewing domestic violence history, trying to find out reasons why any cases might have been dropped and what the circumstances, and also working with our victim service providers. When intimidation does happen, we want to be charging those crimes. And look, you folks are all practicing in, I almost said Mississippi law when I meant Minnesota law, but you all are practicing in Minnesota law. And so your creativity with the Minnesota statutes are going to be far greater than mine, and it's recognized. But what I wanted to offer here is maybe a little bit of a menu of potential intimidation-related crimes. Bribery, especially if they're talking about things that are going to happen with financial status or economic status. If a victim doesn't pursue or go through with it, it might be appropriate for a bribery charge. Tampering with witnesses, which under Minnesota law is pretty broad compared to a lot of jurisdictions. Coercion crimes, and stalking too. And stalking is also one of the most underutilized charges, but think of it. If you have an underlying assault crime and then a subsequent intimidation-related conduct, you're there to a stalking charge, because you're going to have your course of conduct. You're going to have your 2 or more instances designed to put a victim in to cause severe emotional distress and or in fear of bodily injury. So when you do have intimidation, you're going to have a stalking issue. And Dave, I see your hands up.
Yeah, I just wanted to note harassment as well. That, you know, so stalking is just multiple incidents of harassment, which could include an assault. But so you've referenced stalking meaning multiple, but I would think that harassment as a single incident could be a potential charge as well.
That's a great point, and especially and I don't have the exact thresholds for tampering with witnesses. If you're not sure too, if the conduct is going to rise to tampering with witnesses, it's probably also going to, it'll at a minimum rise to harassment standards. And look, as far as I know too, there isn't any rule that's going to prevent you from charging harassment and stalking too. But again, what I was trying to argue though with stalking too is why that's useful as a tool is if you want a charging device that can bring in both the underlying assault and the subsequent intimidation, stalking is a great way to do it without using 404B type motions, because then the conduct that makes up the underlying assault and the underlying intimidation is relevant to a course of conduct. It's not something you're bringing in through a 404B argument where you're saying to the court, please, can I bring it in to show this purpose other than propensity? You can say, I'm bringing in both these instances of conduct to prove my stalking charge. And so in that sense, they can complement one another, which is why stalking is such a useful tool in any kind of domestic violence type investigation.
And if I can just ask as
usually
a
there.
follow-up on that, if I ask as a follow-up on that, so I guess with some of these, it might be a new case that's filed, but I guess what you're referring to then is actually adding as an amended count on your current case, where maybe count 1 is an assault, but now count 2 becomes stalking that includes both the original assault plus some subsequent conduct. Is that right?
That's absolutely correct.
Okay.
And so then you have a charging platform where you can tell the fact finder the whole story of what happened.
Right. No, that makes a lot of sense. Thank you.
Or, heaven forbid, if for some reason you do have to charge them separately, you have vehicles you can bring in the prior assault with. So with intimidation evidence, and here we are having sort of set the foundation, getting to forfeiture by wrongdoing. When intimidation evidence, what do we do with it? Well, the main reason we're here is to talk about how to use intimidation for forfeiture by wrongdoing. But even if our witness is available, but recanting or minimization, just because our victim is available, but recanting or minimizing doesn't mean that this evidence of intimidation isn't worth anything, because it's going to be evidence we can present to not only show an offender's consciousness of guilt, why else would they engage in this conduct unless they knew they did something wrong, but also to help explain or give context to the jury about why a witness may be recanting or minimizing the original assault. And of course, this is especially helpful or can be relevant as an aggravating factor at sentencing. But when intimidation works to the degree that our victim is not available to testify at all, we want to talk about a way that we can still make that press against the defendant and how we can get into victim statements. And I know last time we talked about bringing a victim's voice in, we talked about a lot of exceptions to the hearsay rule, how to build our case without the victim participating, either not at all or through minimization or recantation. Here, we want to talk about how to bring the victim statements in, regardless of whether hearsay exceptions or Crawford rules apply. And that's through the old doctrine of forfeiture by wrongdoing. Now, for folks who've litigated it, some of this might be familiar with you, but we're going to go a little bit into some of the context with it. And the basic concept of forfeiture by wrongdoing, it rests on the underlying premise that the defendant, of course, has a right to confront the witnesses against them. This is fundamental in the Sixth Amendment to the Bill of Rights, the right of confrontation. However, that right of confrontation can be forfeited or waived if the witness cannot be confronted to the defendant's wrongdoing. So in other words, if the defendant's wrongdoing causes and is intended to cause the witness to be unavailable, the right to confrontation is waived or forfeited, essentially. Despite it not always being commonly used or commonly referenced, it's not actually that novel a doctrine. It's existed in the common law from 1666, and I am not familiar with the background of Lord Morley's cases other than it's there, and that's, I think, when forfeiture by wrongdoing concepts were first identified shortly around the time of the Glorious Revolution. But it's been recognized as a doctrine in the United States since 1878 in the case of Reynolds versus US, and this is from 1879. And I'm going to talk a little bit more deeply about Reynolds in a little bit, and it's a rule of equity. Now, Reynolds is an interesting case, and just in if you ever feel like you're sort of digging to the bottom of the toolkit when you're pulling out 19th century cases, Reynolds versus US was actually cited in the Crawford decision. It was cited by Scalia. So even though it's a 19th century case, it's been cited in the 21st century and in a pretty prominent case, such as Crawford v. Washington. But what Reynolds versus US recognized is that this idea of forfeiture by wrongdoing is that it's a rule that has its foundation in that no one should be permitted to take advantage of their own wrong. And the background for Reynolds versus US is pretty interesting because we should actually probably call it Reynolds versus US 2. And this was the 1878 case, because a couple of years before that, Reynolds had also come up in front of the Supreme Court case in that it was a bigamy case from what was then the territory of Utah. And Reynolds had decided to let himself be charged so that he could constitutionally challenge the bigamy laws that were in place. So he was charged, and the Supreme Court said, hey, guess what? The bigamy laws pass constitutional muster. So let's send the case back to the Utah territory where Reynolds can be tried for this bigamy charge. So after the constitutional challenge failed, Reynolds realized he was actually at some criminal exposure. So he had one of his wives abscond to the I don't know if it was a territory or state at that time, but basically leave for Denver. And then said, well, look, you're missing one of the wives, so you can't prove your case of bigamy. You can't present her statements about being married, so you can't prosecute. And the U.S. Attorney's Office or the prosecution then brought in the doctrine of forfeiture by wrongdoing, which was recognized and accepted by the Supreme Court in this 1878 case, recognizing that you can't claim the protections of the confrontation clause if you're the person who caused that witness to not be available. You're essentially forfeiting the benefits of that. And that was the origin of the rule. And it's recognized as public policy, recognizing that if you allow defendants to take advantage of a confrontation clause protections when they cause the witness's unavailability, it would be a subversion of the criminal justice system and inappropriate. So even when Crawford case was being decided, they recognized that all this discussion about testimonial and non-testimonial distinctions and between the hearsay rule and confrontation clause, that was not a concern when forfeiture by wrongdoing was at issue. And really one of the first forfeiture by wrongdoing tests that came up after Crawford was Giles, I believe it's a soft G, Giles versus California from 2008. And this came up in a domestic violence context. What had happened in Giles versus California was the defendant had shot his ex-girlfriend, and at trial, he claimed self-defense. He had shot his ex-girlfriend to death, and he claimed it was done in self-defense. The prosecution in Giles versus California wanted to bring in a 911 statement call that the victim had made 3 weeks before, where she talked about him trying to assault him. And they wanted to bring in that 911 call to show that, hey, look, he was the aggressor. He wasn't scared of the victim. It wasn't valid self-defense. So they brought it in under a forfeiture by wrongdoing. And they just said, hey, look, he killed her. He caused her to be unavailable. We get to bring in the 911 statement. What the Supreme Court in Giles said was, well, not so quick. Forfeiture by wrongdoing is valid, but there's not enough evidence that the victim's unavailability was due to the defendant's intentional act. In other words, the defendant must have specific intent to make the victim unavailable as a witness when committing the wrongdoing. In other words, or to put it yet another way, it's not enough just that Giles made the ex-girlfriend unavailable by killing her. They had to show that part of the reason he killed her was to make her unavailable to testify, or in retaliation, so that she wouldn't be available as a witness, not just that his primary intention was to kill her. So this portion of the record wasn't developed at all. So they remanded it for that to be developed. The concurrence, which as I recall was by David Souter at the time, they talked about in domestic violence cases, the kind of evidence that could show the wrongdoing was intended to make them unavailable is pretty broad, especially in domestic violence cases, where it could be earlier abuse or threats of abuse intended to dissuade the victim from resorting to outside help. It's highly relevant to that kind of inquiry, as would evidence of ongoing criminal proceedings at which the victim would have been expected to testify, like that 911 call. So essentially what they're talking about, hey, look, this intention to cause the victim to be unavailable from wrongdoing, it can be inferred from all this sort of circumstantial evidence. That's entirely appropriate, just like any time we're trying to figure out intent. It doesn't have to be a sort of direct evidence. So Minnesota recognizes forfeiture by wrongdoing in your hearsay rules, 804B6, and this is pretty consistent with what the federal rule reads. Sometimes what's missed in this rule is, of course, it follows under subsection B. subsection A talks about the different kinds of availability. But for forfeiture by wrongdoing, it talks about it applies against a statement offered against a party who wrongfully caused or acquiesced in wrongfully causing the declarant's unavailability as a witness. So a lot of times what's missed is if maybe you have the jailhouse defendant who didn't have any direct contact with your victim, but if there's acquiescence into maybe the defendant's network or family trying to dissuade or discourage the victim from participating, that's going to be enough to trigger this forfeiture by wrongdoing exception if the witness is actually unavailable. Now, that's the other important application of forfeiture by wrongdoing is that the witness has to be unavailable. And this is determined I'm sorry, folks, this should be under A5, 804A5, where they talk about the definition of availability and unavailability as a witness, which has various contexts, but usually for forfeiture by wrongdoing is going to be the witness is absent from the hearing and the proponent of a statement has been unable to procure, in a domestic violence case, that's going to be the state or the prosecution, by process or other reasonable means. So if we have a domestic violence victim who shows up and they're recanting or they're minimizing the abuse, that's not really going to be an opportunity to use forfeiture by wrongdoing. It will be an opportunity to execute some of the strategies we talked about last week, such as prior inconsistent statements that have been memorialized, prior recorded recollections that have been memorialized, statements to medical providers, excited utterances, things like that. But for when our victim isn't available at all, despite our reasonable efforts to procure that person's attendance, then we might be able to use forfeiture by wrongdoing. So what is reasonable efforts? Well, Minnesota's talked about that, at least in a broad sense. I didn't see any case that really drilled down to where it turned on this. But what the state has to show is reasonable efforts to produce a witness and that they were made in good faith. And so the lengths to which the prosecution must go to produce a witness is a question of reasonableness. And they're citing U.S. Supreme Court cases here and State versus Cox from the Minnesota Supreme Court in both Ohio v. Roberts and Barber v. Page, where they're talking about reasonableness to procure efforts. And diving into those federal cases, what those reasonable efforts sometimes come down to is, at a minimum, issuing a subpoena, a writ. If the folks are out of state, maybe preparing an interstate witness subpoena, making offers for travel and lodging expenses. And it's usually also not doing this until the last minute. So our reasonable efforts to get the victim available for trial, it's going to be a little bit more than just contacting them the day before the case, but showing efforts to at least try to get them to court. For reasons I'm going to argue in a minute, I don't think a reasonable effort is going to include a bench warrant, and we can argue against that. And Tara, I see your hands up. I don't know if it was on the bench warrant issue.
It actually exactly was. So thank you. You read my mind.
So what this means is that we want to be prepared at least to make good faith efforts, and not before, but to show that we've made ongoing efforts to get the victim there. Now, the court might say, well, you've issued the subpoena, don't you have to ask for a bench warrant? Let me just sort of talk about other reasonable efforts, and then I'll get to the bench warrant issue too. But we want to show these efforts to produce the witnesses, which at a minimum is going to be, we look for multiple ways to contact them. We've documented all our efforts to contact them. We documented any statements of intention they made not to appear or refuse, and that they've been ongoing and not waiting till the eve of trial. Now, there's not a lot of explicit case law about whether a bench warrant is going to include the reasonable effort. I think within that definition of what we're talking about with Barber here is that the length to which the prosecution must go to produce a witness is a question of reasonableness. And I think you could make a very good argument that, hey, look, a bench warrant isn't going to be reasonable to produce a witness after we've made all these other efforts. And the reason why it's not going to be reasonable is because a bench warrant, or any sort of effort to compel a victim with an awareness of domestic violence context, that's going to be likely chilling the victim's ability to participate in further proceedings. It's going to be criminalizing them. It's going to be making their ability to participate in prosecutions and investigations more challenging and more difficult, and also helping the judge and the court understand that in the context of a lot of power and control dynamics that we talked about that take place within intimate partner violence, or the relationships or context of intimate partner violence crimes, that those kinds of efforts, such as a bench warrant or coercive efforts, are going to be ultimately unreasonable for ability to get justice for the victim and also maintain public safety, because we're going to be creating a circumstance where victims are less likely to participate in the future. So I think those are arguments we can make. The State v. Hobson case, this is from an intermediate appellate court in Washington, has some great language. We believe that whether the state, they address this question head on, whether the state is required to secure the presence of a witness by means of a material witness warrant depends in part on the resulting hardship to the witness and the importance of the witness's testimony. And that was great language. Unfortunately, I know the court of last resort in Washington, they did rule that a bench warrant was necessary, but that's not been the rule adopted in Minnesota. And I think with making a proper record, you could argue why a bench warrant isn't necessary, including talking about some of the resulting hardship that would have on the victim and also the trust of other domestic violence victims that they would place on the prosecution or not place on the prosecution, to show why that's not reasonable to request a bench warrant. So no perfect answer, but just arguments that can be developed. So Cox, which is the seminal Minnesota case, really talks about 4 prongs, which are pretty consistent for forfeiture by wrongdoing. What you have to show in Minnesota is what a lot of other jurisdictions to show, that the declarant witness is unavailable, whatever reasonable efforts you made to produce that witness. The defendant engaged in wrongful conduct. The wrongful conduct caused that unavailability, and the defendant intended to cause the unavailability. Here's a sort of flow chart of how that looks. Now, procedurally, and for folks who've dealt with this, I'd love to hear what your experience. But at a minimum, it's really going to be governed by those parts of the rules of evidence that maybe we don't always examine. Minnesota Rule of Evidence 104. But these kinds of determinations of admissibility, it should be held outside the jury's presence. And I believe what was held in Cox is that the burden that the state has to trigger the forfeiture by wrongdoing exception is going to be preponderance of the evidence. And we already know you can use circumstantial evidence. And so you only have to show by preponderance that the defendant was involved or responsible for causing the witness to be unavailable. And the defendant acted with the intent to cause that unavailability. So what's important to remember, and isn't always sort of commonly referenced, is that an evidentiary hearing under Rule 104, this pretrial determination of admissibility, you're not bound by other evidentiary rules, including the hearsay rules. So what's helpful about that is if you want to prove the wrongdoing, or rather the evidence that raises inferences of which the defendant's wrongdoing can be drawn from, you can use things like affidavits, you can use things like police reports. You don't have to bring in the witness themselves to say they're too intimidated to testify, which of course would be absurd and really never allow the applicability of the forfeiture by wrongdoing exception. You don't need to call the intimidated victim to prove forfeiture by wrongdoing. And the rule that you can cite to the court about for this conduct is going to be Rule 104A. Now, what's the kind of evidence you're going to be presenting beyond your efforts to show the witness, but the evidence you want to be showing? And there's great language from this New York case, People versus Popladero. And I understand that's not precedential in Minnesota, but it's pretty good persuasive language that can be utilized, as you want to show the defendant's knowledge, complicity, or planning in any other way. So with the recognition that the evidence of wrongdoing, that your burden is preponderance of the evidence, and that kind of language that they talk about in Giles versus California, that wrongdoing and wrongdoing intended to cause unavailability is preponderance that can be inferred from other conduct, The kinds of evidence you can show to argue to show the wrongdoing and intention to cause unavailability, it's going to be, of course, things like jail phone calls that maybe aren't as necessary to go through all the authentication hurdles because of 104. The history of the relationship, especially prior incidents of domestic violence, prior criminal and civil cases, not just between this victim and the offender, although those are certainly relevant, but maybe between the offender and other victim. Ideally, if you have witnesses to intimidation, that would be great. And maybe the victim's testimony at prior hearings, including any fear they have of the offender, and any sort of reliance they have on the offender. In prior hearings, I'm not just talking about prior hearings in the case or in criminal cases, but it could also be in custody proceedings, in protection order hearings, things like that, that can all be taken as a whole or under the totality of the circumstances to show wrongdoing, and wrongdoing in which it can be inferred the offender intended to cause the victim to be unavailable. Other examples, of course, a history of abuse, bond hearing evidence might have been used, anything to show what the defendant did to prevent or discourage the defendant from testifying, including jail calls and things of that nature. Things that might also be able to come in as intimidation to show consciousness of guilt during the case in chief, but maybe it doesn't rise to that level. Maybe it is only useful for a forfeiture hearing or forfeiture proceeding. So there are additional resources we have on this because it is exhaustive, and I with the intention of setting the table of a witness intimidation, talking about forfeiture by wrongdoing, but trying to condense it in an hour. I also wanted to leave resources or connections for folks to find other resources to dive in more deeply with this. And you can locate them from equitasresource.org, and these are an example of some of them. Again, and although it sounds like you have a lot of internal expertise and folks who've done this kind of litigation in your office, if you want to see a sample of some sample motions or sample memos to present to the court for forfeiture by wrongdoing, contact me, contact Mary. We can get you samples of those things that you can copy in whole or in part. I recommend you at least sort of incorporate Minnesota law into them, and we can assist you in that too, if you like. So going forward, what we're talking about, and hopefully what we've covered, is trying to identify overt and subtle forms of intimidation, educating victims about intimidation, proactively investigating intimidation, preserving those admissible out-of-court statements, because again, once you have this forfeiture by wrongdoing invoked, you can bring in any statements the victim made. You don't have to go through whether or not there's another valid hearsay exception. You don't have to jump the hurdle of whether or not it's testimonial or non-testimonial. Basically, if it's an interview with a detective 5 days after the assault in preparation for hearings, if the forfeiture by wrongdoing exception applies, that's the kind of statement that can be brought in. And it's one that the offender isn't going to get a chance to cross-examine because they forfeited it. And ideally, you want to set up foundations where you can litigate these the admissions of these statements pre-trial. So that brings us right to the end of the hour, 1 o'clock your time, 2 o'clock mine. I can certainly stay on if folks aren't in a rush to court, if there's any sort of conversation, other topics you'd like to address. And I'll actually stay on until everyone leaves, just in case there's things you want to talk about outside the time. But I hope you found this productive, and I really thank everyone for their participation and attention.
Thanks, John. This was excellent. Really appreciate your expertise in this area. I do have a quick question, and for anybody who's still on the call, but of course, forfeiture by wrongdoing, sort of by in name, sort of infers that the kind of conduct we're talking about is the thinking back to your previous slide about the different types of intimidation and manipulation, I guess, it kind of assumes these threats and things like that, or conduct that gets the person to not want to participate. Have you had any success in arguing that the dynamics of DV, the kinds of things like, I'm sorry, it'll never happen again, those kinds of things, have been a sort of a basis for a forfeiture by wrongdoing. And what are your thoughts on that?
Yeah, I think there's a broader basis to argue forfeiture by wrongdoing than there is intimidation. And so in one sense, the wrongdoing for 804B6 is broader than intimidation, which I think has a higher threshold, because wrongdoing, I think just by plain use of language, is a lower threshold. But again, also in the context where you have to show it, where one, it establishes and can be raised by inferences from other conduct, and that the burden is only preponderance. So in that sense, I do think the emotional appeals, the I'll never do it again, you can raise an argument and like, look, judge, it's more likely than not, while there may be other explanations for this, one of the reasons in this jail call, he's saying, I'm sorry, this will never happen again, is to get this victim to not appear or to be unavailable for court, despite our efforts to produce her. And this is also fortified in the context of these 3 other cases that have been filed and dropped because the victim couldn't be found. And just in the context. So I think, judge, under preponderance, it's more likely than not that this was wrongdoing intended to make the victim unavailable.
Are you aware of any case law in this? I mean, I've thought of that before. I've never litigated it in that context with just the apologies and the more manipulation than intimidation. But I've thought that maybe
Yeah, I can probably find one because I remember seeing it in one or another jurisdiction. I
don't mean to send you on a. I was just curious if you'd ever run across it.
I mean, one or times another when I was preparing this, I remember seeing cases like that.
Yeah.
I don't remember seeing anything about Minnesota specifically about it, but Minnesota is pretty generous too with victim behavior nowadays. It's generous with victim behavior. And so that might be one strategy too at your forfeiture by wrongdoing, is to bring in a victim behavior expert to talk to the judge about these dynamics and victim behavior too.
Yeah, good idea. Thank